webinar with the topic Foreign Companies Incorporation. So my name is Ian. Together with my colleagues Somya and Joseph, we will be your facilitator for today. So if it is your first time with us, we are glad that you join us in this amazing discussion. So we'll be tackling a very, very interesting topic. Okay, so basic house rules. I would like to request everyone to put your microphones on mute while we are on session. And then questions will be addressed during the Q&A part after these presentations. All right. So having said, we have 3 speakers for today. So let me introduce them. Our first speaker is Mr. Kai, or shall we call him Mr. Keith? He's an expert in assisting clients with matters on corporate, onshore, and offshore foreign investments, M&A transactions, labor and employment, real estate projects, metro projects, franchise, and franchise stores. Okay, he is also acted as a counselor for Vietnam-based Bank of China, Keppel Land, a property investor, Family Mart, Conseil Marine, and many more. All right, so our second speaker, she's always been with us, Christine Ko, is the principal partner of Christine Ko and IP Solicitor Notaries LLP based in Hong Kong. Ms. Christine has over 30 years of experience gained from government and private sectors in Hong Kong and overseas, including working in-house for an international insurance corporation. Okay, so then we have another new speaker, Ms. Joyce Yang. Ms. Joyce is specialized in cross-border investment and financing, corporate finance, and private equity fund, focusing on biotech, new energy, and internet. She has a proven track record of advertising large institutional investors, government guidance funds, and various financial institutions, as well as providing financial-related legal services to both startup and enterprises in different stages. All right, so I know that everyone is now excited to learn. So let me hand it over to our first speaker, Mr. Keith. Mr. Keith, please take over.
Hi, sorry, you're on mute. We're unable to hear you, Mr. Luong.
Mr. Kai, you are muted.
Hello,
yeah.
could
Mr.
you?
Kai, you are muted.
Yes, we can hear you now.
Okay, could you hear me?
Yes, we can hear you now.
I would like to show my slide, but it cannot share it to you. Okay, could you see my slide?
Yeah, no problem. Yeah, no problem.
Okay, I would like to talk about the foreign company incorporation in Vietnam. Today we will talk about 3 main issues. The first one, there is the business setup, registration, and approvals. The second one, the tax and relevant incentive. And the third one, the final one, or the issue. The first one, I would like about the business setup, registration, and approval. In this section, we will talk about 7 matters. The general regulation on investment, the condition for market approach, the foreign shareholding limitation, necessary license and certificates, the power and authority to approve an investment project in Vietnam, the investment incentive, and where can an investment project domicile. Now, the first one, general regulation on investment. At present, the foreign investor may make the investment in Vietnam in one of the 5 forms The first one, there is incorporation of a new enterprise. The second one, you can purchase by the capital contribution, purchase of shares or purchase of capital contribution portion in an existing company. The third form, there is implementation of an investment project or investment on the basis of a business corporation contract. And the last one, the last form, that is the new form of investment, which may be stipulated by the government from time to time. Now, I would like to mention about the condition for market approach. Okay, this condition is set out by the government for the foreign investor. And these conditions, they are include maybe the condition for the foreign shareholding ratio in a foreign invested enterprise. Maybe the condition for the form of investment, the condition for the scope of investment operation, or the capacity of the investor and partners to participate in the investment operation, or other conditions which may be stipulated by the law or by the international treaties. At present, the government of Vietnam issued 2 lists. The first list, there is the list of business line not permissible for market approach. It means that the foreign investor cannot make the investment in some business line. And the second one, there is the list of business lines subject to the conditional market approach, which means that the foreign investor can make investment in this business line, but it is conditional. And number 3, the foreign shareholding limitation. We have a concept, there is the foreign shareholding limitation. It is the maximum shareholding ratio held by all foreign investors in an FIE. This limitation shall be dependent on the minimum shareholding ratio derived from all business lines of the FIE. For example, the FIE, the company, has 3 business lines. Business line number 1, the foreign investor can hold 100% of the capital. The business line number 2, the investor can hold more than 50%, and the business line number 3, the investor can hold 49%. So the foreign shareholding limitation in this case shall be 49%. It means that the foreign investor can hold only 49% of the capital of the FIE. And if the limitation is more than 50% of the charter capital of the FIE, the investment registration shall be required. The charter capital, in Vietnam, we have the concept of charter capital. Maybe you can understood it is the authorized capital in the US or the paid up capital in other countries. Next, I would like to talk about the necessary license and the certificate. In most common cases, the foreign investor will need 2 certificates. The first one, there is the investment registration certificate, we call IRC. And the second one, there is the enterprise registration certificate, we call ERC. The investment registration certificate will mention about all information about the project, the investment project. And the ERC, the enterprise registration certificate, will mention the information about the company which implement the investment project. I would like to talk about one special document. In Vietnam, we call it the investment in principle approval. This approval must be obtained before we get the IRC and ERC. So in which case we will need the investment in principle approval. So I will talk about later. In the form of share purchase, the foreign investor shall register for the share purchase if it falls within the compulsory cases by law. And if the business line of the company, the FIE, fall within the conditional business line, so the sub-license shall be required. Okay, number 5, I would like to mention about the investment in principle approval. The investment in principle approval shall be issued by 3 authorities. 1, there is the National Assembly. There is for the very, very big project. And the second one, the approval issued by the Prime Minister. It will be used for the big projects. And the third one, the approval shall be issued by the Provincial People's Committee, we call it PC, the Provincial People's Committee, or the authority of the industrial park, or the high-tech zone authority. This case will be used for projects using land. It means that the project, the investor have the demand on using the land. Now I would like to talk about the timeline for issuance of the approval. For the investment in principle approval, in normal cases, we will need 35 days if the approval issued by the People's Committee. And in case it fall within the power and the authority of the Prime Minister or the National Assembly, so the duration for issuance of this approval is unidentified. In case of the IRC, the duration will be 5 business days or 15 days, as the case may be. And in case of the approval for registration of share purchase, the timeline, the duration will be 15 days. And the ERC will be issued within 3 business days after issuance of the IRC. And the sub-license, the timeline for the sub-license will be dependent on the conditional business line. Now, the government of Vietnam provides some investment incentive to the foreign investor. These incentives include 4 items. The first one, there is the incentive on the corporate income tax, the CID, the incentive on exemption from the import duty in some cases, or the exemption, the investor may be exempt from or reduction of the land rent, land use fee, and land use tax. And the investor may have the incentive on accelerated depreciation and increase in the amount of deductible expense. So where can the investment project domicile? Where can we place the investment project? In Vietnam, the land is under the joint ownership of the entire people of Vietnam. It means that all peoples of Vietnam is the owner of the land, and the state acts as the representative of all people of Vietnam to manage the land. So any individual or organization or even the foreign invested enterprise will have only the right to use the land, and they will not have the right to own the land privately. And in Vietnam, we have 2 cases. The common cases, the term of use of the land for the investment project will not exceed 50 years. But in some special cases, the term of use of the land shall not exceed 70 years. And So where we can place the investment project? The investment project can be placed situated in the industrial park, in the processing zone, in the high technology parks economic zone, or you can put it outside the industrial park, outside the zones. However, if we put the investment project inside the parks, we will receive additional incentive from the industrial park. And that is the difference between the inside and outside the park. The second section, I would like to talk about the tax and some incentive related to the tax. In Vietnam, you will concern about 5 issues. The first one, there is the corporate income tax, CIT, the value-added tax, VAT, the personal income tax, PIT, the environmental protection tax, EPT, and the double taxation agreement between Vietnam and other countries. The first one, the corporate income tax. Now, Vietnam have 5 rates. The first one, there is the normal rate, the normal CIT rate. At the present time, it is 20%. And if the enterprise operates in oil and gas industry, it will range from 32 to 50%. And in platinum, gold, silver, tin, wolfram, antimony, and gemstone. So in this sector, the CIT rate will be 40% or 50%. And Vietnam have the preferred rate at 10% for 15 years, and the special rate 5% to 10%. Okay, now I would like to talk about the preferred rate at 10%. So which company will enjoy this rate? So we have 5 cases that the foreign the investment project can enjoy the preferred rate. The first one, that is the investment will be made in the geographical areas with special difficult social economic conditions. It includes about 54 province and city. The project for scientific research and technological development, high technology enterprise, or manufacturing sectors, except for manufacturer of lights of goods, subject to the special consumption tax. In other countries, you may know it is as the excise tax. And except for the mineral mining projects. And the last one, the investment project for manufacture of supporting industrial products prioritized for development. If we fall within the eligible entity, we will enjoy the preferred rate, CIT tax rate at 10%. And the duration for entitlement of the preferred rate is 15 years. So after 15 years, you may also enjoy the exemption from the CIT for a maximum period of 4 years next, and 50% reduction of the amount of the CIT payable for a maximum period of 9 subsequent years. So this is about the preferred rate at 10%. The next one, I would like to talk about the special rate. The special rate will be applicable to the very special cases. As you can see, the investment project must be in the sector of research and development centers, creative renovation centers with the total investment capital of about 128 million US dollar. And the disbursement must be made at least about 42.66 million US dollar within 3 years. And the second case for the investment project has the investment capital of about 1.28 trillion US dollar or more, and the disbursement of the capital must be at least 42.66 million US dollar within 3 years. So if the investment project fall within two cases, the investor or the FIE will enjoy the special rate, CIT rate at 5%. And the duration for the special rate, by law, it is stipulated by law that the rate will be ranged from 5% to 10%. But the particular tax rate, for example, 5%, 6%, 7%, or 8%, or 9%, or 10%, will be decided by the Prime Minister. And the duration for entitlement to this tax rate will be decided by the Prime Minister as well. But it will not exceed 1.5 of 15 years. It means that 37.5 years. This duration may be extended, but the extended period must not exceed 15 years. And in addition, the enterprise who enjoy the special rate can enjoy the CIT exemption and the CIT reduction. But the CIT exemption will not exceed 6 years, and the duration for the 50% reduction of the amount of CIT will not exceed 13 subsequent years. The second tax, I would like to mention the VAT exemption, the value-added tax. At present, Vietnam provided 25 cases where the enterprise can be exempt from the value-added tax. And the normal rates in Vietnam, we have three rates: 0%, 5%, and 10%. 0% is for exports. I mean the exported goods and service and international transportation. And 5% will be applicable to products and fresh fruit in the form of raw materials, medical equipment, educational tools, books, toys for kids, activities of culture, sports, artistic performance, film production, importation, distribution, and film projection. 10% is the normal rate for almost of all enterprise in Vietnam. And at the present time, Vietnam have a temporary rate at 8%, but it temporarily applicable until the end of 2022 because Vietnam suffer from the COVID-19, and this is the temporary rate to help the enterprise to recover the economy. The PIT, personal income tax. You can see the table. This is the tariff for the resident in case of income from the salary or remuneration. And this is the tariff for the resident. The next one, there is the tariff for the resident and the non-resident with income come from all the sources. For example, for the employment income of the non-resident at present, it will be 20%. If the income from the capital investment, 5%. I would like to mention item number 6, the income from capital assignment. For resident, it is 20%. For non-resident, it is 0.1%. But there is a difference in the formula. For the resident, the rate 20% is applicable to the balance between the selling price minus the buying price. For the non-resident, the rate will be 0.1% of the assignment price or the selling price. About the environmental protection tax, this tax will be applicable only to the production and importation of some goods that is have an impact to the environment. So if the production or the importation of the foreign investor do not have any impact on the environment, you will not be subject to this kind of tax. Next, the double taxation agreement. At present, Vietnam have entered into 80 agreements with 80 nations nationwide. And the double taxation agreement almost mentioned and applicable to the personal income tax, the corporate income tax, and levy on repatriation of profit from Vietnam back to the home country and vice versa. So now the foreign investor may have the incentive on the double taxation agreement. The last issue I would like to talk about 4 matters. The first one, the currency control. Under the law of Vietnam, all transactions must be specified and paid in Vietnam dong currency, except for 17 cases as permitted by law. About the repatriation of profit and excess, the government of Vietnam allow the foreign investor to repatriate their capital, their proceeds, their lawful income from the investment incentive and all the kind of money and access. As long as they are lawful, the foreign investor can repatriate them back to their home country. The foreign employee or the expatriate employee, Vietnam do not provide any quota on the number of the foreign employee. It means that the foreign investor can employ the foreign employees. However, the government of Vietnam provides the condition for recruitment of the expats. The simple rule is that if the Vietnamese employees are not able to satisfy the requirement for some position, it means that the foreign employee can work at such position. The work permit and the certification of exemption from the work permit. All foreign employees who works in Vietnam must have the work permit. And if they fall within the exception cases, they must have the certificate of exemption from the work permit. And the maximum term for the work permit and the certificate is 2 years. And the last issue, protection of the foreign investor. The government of Vietnam undertake to the investor that they will protect the foreign investor. The lawful access of the investor will not be nationalized, will not be confiscated by the government. If the government wish to buy them, the government will negotiate with the foreign investor to buy the access. And the government of Vietnam will not force the investor to take some action, like they will not force the investor to use the local goods or service. They will not force the investor to export the good at a fixed percentage, rare percentage, or you must export to some country. No, the government of Vietnam will not force the investor to do so. And some similar action like this. So that is the end of my presentation. Thank you very much for your attention.
Thank you. Thank you so much, Mr. Luong. That was really informative for all of us.
Thank you so much, Mr. Luong. It was really informative for all of
I
us.
now welcome our second speaker of the day, Ms. Christine.
Welcome our second
Christine, the
speaker
floor is
of the
open
day,
to you.
Ms.
You can go
Christine.
ahead.
Christine, the floor is open to you. You can go ahead.
Hi, everybody. Can you hear me?
Yeah, we
Yes.
can hear you. Thank you, Christine.
Good. Thank you. And I'm going to speak on the foreign. Well, when you say foreign investment, I suppose you mean a foreigner coming to Hong Kong to incorporate a company. So I got the impression that Sumaya, would you? Yes, please. Thank you. This is you can skip this. I mean, this is just exemption clause. Now, with this, I'm going to talk about the types of company in Hong Kong. First of all, my presentation will be very short because Hong Kong has got nothing special. There is no differentiation between a foreigner and a local people who wants to incorporate a company. There is no special law for the investor as to how much money he should put into his company. Unless, of course, you want to set up a bank. If there's a bank, then of course there is something. But if it's just a normal trading company, a holding company, there's simply nothing to stop you from doing so. You can incorporate it in, in whatever currency. I mean, you can change it to whatever currency that you want. So for the types of company in Hong Kong, there is public company. The public company usually are for listing purpose. So if it's going to be listed, it has to be a public company. If it is a private company, then you can have any number of shareholders that you want. But at least, of course, one company should at least have one shareholder. For a publicly listed company, you can have as many as you want, right? There is a third type of company called company limited by guarantee. This is for special purpose, which if I have time, I will go into it, but if not, I will just skip it. For incorporating a company in Hong Kong, that's fine. I'm going to talk about it. However, you can also have company incorporated overseas. For example, if the company is a Vietnamese company, like Keith has just told us, the company can come here to do the trading in Hong Kong. They are welcome. So you can have a company incorporated anywhere in the world, come to Hong Kong and simply do a simple registration by filing a form, finish in 2 seconds, and then you can do the business here in Hong Kong. Open a bank account, and there you are, start doing business. So the fourth question is, can a foreigner form a company in Hong Kong? Now, if the foreigner is in Hong Kong, definitely he can. If the foreigner is not in Hong Kong, again, he can. So a company formed in Hong Kong or set up in Hong Kong can have a foreign shareholder, a foreign director, although it must have a local company secretary. That is quite logical. I mean, the necessity is easy to see because government will send you letters. You will have to do the filing, so you need a local company secretary to help you with all this. But otherwise, you can have foreigners, and there's no differentiation between foreigner and local people. Next one, please. A company in Hong Kong must have a shareholder. Sometimes you call it a member, and then a director, and then you have shareholders and directors, company secretary. Oh, the other thing is to have a registered office. Registered office means the office address, which is the official address that you receive things from the government, from other who want to send you a letter, Of course, you can now, these days, you can have email and so on, but still letters are sometimes required. So these 4 elements are necessary. Next one. The types of companies in Hong Kong, where I've just mentioned, you have a public company, private company, company limited by shares. The purpose, public company with the listing. For example, the Hong Kong Bank. Hong Kong and Shanghai Banking Corporation, it is now a British company, but it is listed in Hong Kong. It had been a listed company for a long time. There are a lot of listed companies where these are formed in Cayman Island, in Bermuda, in China. They can all come in to be listed in Hong Kong. There's no change, no criteria, no threshold. You can do probably whatever you want to be. So this is one thing. The maximum number for a private company, you can have 50. You should have no more than 50 members, i.e. shareholders. Although you can have 1. So between 1 and 50, you will be fine. For listed company, if it's listed in the stock exchange of Hong Kong, you should have at least 300 members. You cannot have just 200 members, for example. It's not qualified for listing. But the maximum number is unlimited. And for company limited by guarantee, again, between 1 and unlimited. Next one. It is a good place, perhaps I should say something like, in Hong Kong, there is no prohibition list. You can have the company do whatever you want, provided that it is lawful. And provided that the company in Hong Kong, you can do the things like mining. When I say mining, it doesn't mean that you go and to dig up the iron or dig up the oil or dig up the gold. But you can do like cyber activities, the mining for the cyber activities. There's no special license, no requirement of the capital. Oh, one of the things about the capital. The capital, you can have a $2 company. In Hong Kong, we always say this is a $2 company, meaning the capital is, well, we usually say $10,000 Hong Kong, which means around 1,250 US dollar, and that's it. But then again, for that capital, you don't even need to be paid up. All you need to pay up the capital is $2. So usually it's called a $2 company. Now let me come back to directors. The director, you should have 2 directors for a public company at least, and then a private company, 1 at least, to the unlimited. Unlimited number. But then of course you won't have a lot of directors. The company secretary, usually every company should at least have 1. You can have a lot, but there will be a waste of money, so nobody is doing that. For the office, 1 registered office, meaning 1 official office, that's a must. And you can have as many branch office as you want. There's no special requirement as to how many you can have and you cannot have. So far I'm saying everything is free. You can have no limitation. You can have number. Oh, there's no ratio between foreign shareholder and local shareholder. You can have like 100 shareholders all being foreigners. That's fine with Hong Kong government. You can have 1 foreigner setting up a company. That's also fine. You can have 1 local plus 1 foreigner. Yes. You can have all locals. Yes. Anyway, there's nothing to limit you, to regulate you. The only regulation that Hong Kong has for the company is the annual filing. We call it the annual return. You have to report to the company's registry annually that if there's any change with the directors, any change with the company secretary, or any change with the register office. And then, of course, you need to do the filing for tax return, but that's another matter. For the tax, if you make money, you file tax return. I will go to tax later on. But all I want to emphasize is there is no special rule for foreigner. If a local can do, you can do. If a local doesn't do, you can do as well. For example, you can put the company name apart from the English name, a Chinese name, maybe a European name on it. Nobody cares, as long as people can pronounce it. Sometimes we cannot pronounce. Like a few years ago, 20, 30, 40 years ago, I was asked to go to cocktail party. He told me the party was thrown by Ferragamo. I looked at the invitation card. I don't know how to pronounce the word Ferragamo at that time, so I rang up their secretary. Secretary, oh, this is a worldwide known brand name and you don't know it. Sorry, I don't. So you see, you can call you can call it Ferragamo, Christini, or whatever fanciful name you want to. Now, the amount of investment into the company, it is absolutely up to you. Of course, except, as I said, like a banking business, an insurance business. But I suppose these two are all. These two are, except you want the company to be a publicly listed company trading in the stock exchange where your shares are traded. Otherwise, there's no regulation, no limitation at all. And there's no import tax, no export tax, no VAT, nothing. No capital gain. Next, please. The company incorporated in Hong Kong, some, you have a Hong Kong citizen and you can have foreigner as shareholder. You can have the company incorporated overseas. Oh, in Hong Kong, we have a lot of companies incorporated overseas, mainly incorporated in BVI and in Cayman Island. For BVI, of course, it is for tax purpose at that time. And for Cayman Island, it is mainly for listing purpose. If you want to list your company in the stock exchange, usually people form a BVI, form a Cayman company and then list the Cayman company there. So, in fact, we've got a lot of foreign companies now trading or doing business in Hong Kong. For foreigner and for shareholder, there's no residential requirement. You can be a Hong Kong citizen, but you are living overseas, you can be a shareholder. And vice versa, you can be a foreigner, you live in Hong Kong, yes, you can be a shareholder. Or you are a foreigner living in a foreign place. Anyway, there's no restrictions. Okay, next one. What else? Can a foreigner incorporate a company in Hong Kong? Yes, of course. Shareholder is a foreigner, director is a foreigner, except, as I said, a company secretary. Okay, next one, please. Tax. Now, this is the most interesting part. In Hong Kong, the only tax that we have is stamp duty. Stamp duty on share transfer. If you want to buy, sell, and buy shares, you need to pay 13%, meaning $1,000, you pay $13. So it's 0.13% on the bought and sold note. When you transfer the share, you do a bought and sold note, and the stamp duty is 0.13. It's really, really negligible. When you have profits, when your company makes profits, then the tax is between 8.25 to 16.5. Now 16.5 12.5 will be the maximum. Even you make billions of dollars, it will be 16.25. Mind you, the tax is for assessable profit. And for assessable profit, as we all know, there are a lot of deductions. You can deduct your expense, your car, your staff, maybe your driver, anything you can think of. Some people even deduct their contribution to the retirement scheme, retirement fund. There are no other tax, no withholding tax, no VAT, no capital gain tax, no what, oil tax, consumption tax, whatever, no import tax. Hong Kong is a no tax city, so to speak, and I like it. But the thing is, as a lawyer, it means we don't practice tax law. There's no need to practice tax law, so to speak. And the fee for incorporating a company in Hong Kong is really low. I understand from Keith that you have to have in principle approval, and then you have to wait a week or so for the formal approval. In Hong Kong, no. If you want to form a company, I can form it for you within 3 days. Maybe if you want, I can buy a pre-listed, we call it a shelf company, pre-incorporated company, and finish it within 2 days just by changing your name over, and that's it, you have a company. And you can start doing business right on that day. Now, for the fee, incorporation is again really low. It's about $1,000, that sort of range, and you don't even need to inject any capital. You can say my company has a capital amount of $1 million. However, you don't need to like actually attribute or contribute that $1 million. All you need to do is you tell the world that you have $1 million, and by the time it got wound up, hopefully it's got $1 million left. If not, the company will be wound up, and that's it. For the money that's come in and go out, yes, you can repatriate them anytime you want, wherever you want, whichever currency that you want. There's no limitation, no restriction. And what a lot of people do, even in the recent years, is that they form a company here in Hong Kong, taking advantage of the low tax regime, have Hong Kong being the center of the management of his group of company. So if a company in a high tax regime making millions of dollars, he pay his profit to a Hong Kong company in the name of a management fee. And the management fee and making the Hong Kong company making a lot of profits. But then the profit is only, well, how much? Between 8% to 16%. So that profit is paying only 8 to 16%, thereby cutting down on the profit that actually made in that high tax regime company. So that has always been done. But of course, these days, a lot of countries are clamping down on this kind of practice. But well, one can always have another method of saving tax. Let's move on. Oh, this Q&A, I give it to you. Can a limited company, be it a Hong Kong incorporated company or a foreign incorporated company, be a shareholder of a Hong Kong company? Let me see. Answer yes or no. You give it. You show it in the chat box. Say yes or no. Hey, so that I know you are listening. Anybody give me the answer? Or you can unmute yourself and tell me the answer. Anybody? Hey, no one's there. Anybody there? Well done. Who is CSY? Well done. Let me see your face, CSY. Thank you. Oh, we've got a lot more chat. Oh, you. Joyce. Yes, thank you, Joyce. Yes, CSY and Walter. Oh, thank you. Thank you, guys. Yes, anybody can be a foreign company, a limited company can be a shareholder as well. Meaning usually a holding company is incorporated in that way. And if you have any questions, just let's do it when we finish the talk. Is that okay? Sumai, is that okay?
Yes, I think we can take the questions towards the end when we're done with our third speaker as well. I think.
Yeah, good.
Yeah.
Thank you. So that's the end of my presentation because it's so simple, so straightforward. There's not much rule, and that's why I don't have much to say. I'm sorry to tell you, but anyway, to us, forming a company in Hong Kong is too simple to be a big subject on its own. So that's why. So I must apologize to you.
No, but it was either way, it was really interesting for us also to know about the $2 company especially. So thank you, Christine.
Thank you.
Thank you for your presentation. We now welcome our third speaker, Ms. Joyce Yang. Ms. Joyce, the floor is open to you.
Okay. Can you hear me? Okay.
Yes.
Yeah.
I can hear you.
Okay. The next slide. The next page. Okay, thank you. The deepening of Chinese reform and opening up has led to a steady growth of its foreign investment, especially in developing countries characterized by the highest scale of capital attraction. In 2021, China's actual foreign investment reached 1.15 trillion RMB, 62.9% rise from 2012, ranking second in the world. At the same time, with further improvements of the Chinese legal system and the environment for foreign investment, more and more foreign invested enterprises are being incorporated in China. According to statistics, more than 23,000 new foreign invested enterprises were established in 2021, an increase of 47.9% compared to 2020. China's gradual recovery from COVID-19 will result to a significant increase in the number of incorporated foreign invested enterprises. However, to incorporate in China, foreign invested enterprise first need to register. I will give a brief introduction about the incorporation of foreign invested enterprises. I will firstly introduce the basic conditions for the incorporation of a foreign invested enterprise in China and the form of organization of foreign invested enterprise is, followed by the process required for incorporation. Finally, I will further explain the important considerations for incorporation and talk about some specific issues. Next page, thanks. Okay, first, we should know the basic conditions for the incorporation of foreign invested enterprises, the threshold of incorporation negative list. According to Article 28 of the Foreign Investment Law, a foreign investor may not invest in a field which is prohibited by the Foreign Investment Access Negative List from the investment. To invest in a field restricted by the Foreign Investment Access Negative List from investment, a foreign investor shall meet the investment conditions set out in the negative list. For fields outside of the foreign investment access negative list, investment administration shall be conducted under the principle of equal treatment to domestic and foreign investment. Further, Article 34(1) of the regulations for the implementation of the foreign investment law states that in their performance of duties in accordance with the law, the appropriate departments shall not handle the licensing and the price registration and other relevant matters for foreign investors intending to invest in the fields on the negative list, but failing to comply with the provisions of the negative list. And if the confirmation of a fixed asset investment project is involved, shall not handle relevant confirmation matters. Therefore, the first thing to do is to review the company in accordance with negative list issued to determine whether it can meet the threshold. Next page. This is the specific contents of the next list are as follows. The first is about the special administrative measures for foreign investment access negative list. And if in the pilot free trade zone, there is some other special regulations. We can see there are 31 items in the first regulation covering the following industries. For example, agriculture, forestry, animal husbandry, and so on. You can see this, the words yourself. Yeah. The next page. Next, I will introduce you about the forms of foreign invested enterprises. In China, there are 3 common organization forms for foreign investors to set up. First is the permanent representative office, and the second is a company. We have two forms: the limited liability company and the company limited by shares. The second is the partnership enterprise. The representative office is not an independent legal entity, and the responsibility shall be borne by the foreign enterprise. The latter 2 organizational forms will be borne by themselves. With regard to companies set up by or with foreign investors, they need to follow the company law and the partnership law as applicable. Pursuant to the new foreign investment law, which took effect from January 1, 2020. I will detail the most commonly used, the limited liability company, LLC. It's managed by board of directors or a single executive director, usually adopted by LLCs with a limited number of shareholders and is responsible for a relatively small size of operation. And is responsible for making major business decisions and overseeing general operations. The shareholders meeting represents the highest authority, and the senior management officers run the day-to-day operations. They are led by a general manager appointed by the board of directors or executive director. And as a final reminder, partnership enterprise is not a separate legal person entity. Partnership agreement sets forth the management of the business. One or several general partners can be designated to manage the business. Next page, please. Okay, next is about the foreign invested enterprise incorporation process. After the foreign invested enterprise has completed reviewing the negative list and the company's form of the organization, it can apply for incorporation with the relevant Chinese authorities. The specific process is as follows. First, you need to go to the Administration of Market Regulation to get the pre-approval of enterprise name and determine the name of the enterprise and the business registration and obtain a business license to operate. And then go to the Public Security Bureau to obtain official seal, financial seal, private seal, and of legal person, and the other relevant seals. And next, the tax office to complete the initial tax registration and the application for general taxpayer, and then the bank to open basic bank accounts, and the state administration of foreign exchange to open foreign currency accounts. And you may go to customs if applicable for customs file. The next page. And for example, this is a list of main materials required by an administration of market regulation about foreign company registration. There are the application for company registration, articles of association, shareholders and promoters' main qualification documents, or proof of identity of natural persons, the appointment documents of legal representatives, directors, supervisors, and the senior management, and the documents on the legal use of the residence. Okay, next page. And there are some notes on the incorporation of foreign-funded enterprise. First, I will talk about the name. The relevant authorities require foreign invested enterprises to pay special attention to the name because they have specific requirements for an enterprise name. The name of the enterprise shall consist of the following parts in order: name, industry or business characteristics, and the form of organization. The name of the enterprise shall be the name of the administrative region of the province, province or city or country where the enterprise is located. The name shall not be identical or similar to the name of an enterprise in the same industry already incorporated within the jurisdiction of the competent registration authority. According to the regulations, the words China national can be included in the name of an enterprise only after meeting specific circumstances and being approved by the state administration of market supervision. And second is about the shareholder. The shareholders of a wholly foreign-owned enterprise can either be a foreign company or a foreign resident. In contrast, the Chinese shareholder of a Sino-foreign joint venture must be a Chinese company but cannot be a Chinese resident. The establishment of a foreign-funded enterprise requires shareholders' proof of identity. If the shareholder is a foreign invested enterprise, a foreign enterprise, a notarized certificate of legal establishment is required. Well, if the shareholder is a foreign individual, a notarized passport is required. Next is about the supervisor. An enterprise with a supervisory board requires at least 3 supervisory members. However, one supervisor is sufficient if there is no supervisory board. Supervisors may be foreign individuals or mainland resident. Proof of supervisor's identity is required at the time of registration. Next is about the directors. When a foreign invested enterprise is established, it may or may not have a board of directors. If there is no board of directors, there must be an executive director. The executive director can be either a mainland resident or a foreign individual, and proof of identity is required. The fifth is about the legal person. Foreign invested enterprise require a legal representative who can be hired or one of the shareholders. The legal representative of a foreign-funded enterprise or a Sino-foreign joint venture can be either a Chinese or a foreigner. Proof of identity and a photograph of the legal representative are required. Next is about the address. The address of the foreign invested enterprise must be a commercial office address, and it is also necessary to provide a lease agreement, a copy of the property certificate. And the last one is about the registered capital. Foreign invested companies are no longer required to make actual capital contributions, but the next page, please. but the ratio of their registered capital to the total amount of investment shall comply with the following provisions. You can see this table. There are some number. If the total investment is below $300 million, the minimum ratio of registered capital to total investment needs to be 7:10. Yeah. Okay, that's all for today. Thank you very much for listening.
Thank you, Ms. Joyce. That was really informative. The floor is now open for questions. So if anyone has any questions, please feel free to, or else, yeah, please feel free to either drop it in the chat box or you can direct it to the speaker. So any questions, anyone? If not, we'll wind up the session. So I'll just wait for a minute. And if anyone has any questions, please let us know.
Yeah, if anybody has any question, you can always send us or any speaker an email, and we can clarify them on this or on the email. That will even be clearer, even be easier, isn't it? Yeah.
Yeah. Looks like we're good for the day. So if anyone has any specific questions, you can always write to us. So you can drop us an email and to the speakers or to us, and we'll get back. So thank you everyone for joining today. It was really nice seeing you all, and I hope to see you all in the next webinar, the details of which will follow. So thank you and have a good day. Thanks everyone. Bye. Bye.
Thank you. Bye.
Bye. Thank you.
Bye.
Goodbye.
Thank you. Bye.
Bye. Thanks.
Bye.
Bye. Thanks.
Thanks. Bye.